this episode, we have none other than Mr. Joe Ferry with us, the home inspector lawyer. We ask him who actually owns the home inspection report. His answer may surprise you. Don't miss it. This is Inspector Toolbelt Talk.
Welcome back to Inspector Toolbelt. I am super excited about our show today. As my guest here today just put it, let's light this candle. We have Joe Ferry on, the home inspector lawyer himself. Joe, thank you for being on today.
I'm happy to be here, Ian.
Yeah, thanks. We were just chatting before we hopped onto this podcast and just talking about a few things. If you don't know who Joe Ferry is, first of all, what rock have you been under?
Right.
You should really know who Joe Ferry is. He is the home inspector lawyer. You can go to joeferry.com and find out a lot about him. He also sits on the board of directors for Internashi. I have known about and known Joe my entire inspection career. All three of my companies have used him and still use him to one extent or another. So I'm just excited to have you here, Joe.
I'm as excited as you are, Ian, because I think this is a tremendous format, and it's my whole existence these days, my whole professional existence is about educating home inspectors and helping them out.
Yeah, and that's what I really appreciate about you. For instance, Claims Academy, one of the services that you offer on joeferry.com is free. Home inspectors can just go in there and learn about these legal matters that to help them out with their business, which is important because we're inspectors. We're not attorneys. We don't always know this stuff. And you offer that information free, which is incredible.
Yeah, and I've been doing this for almost 20 years now, and I've probably responded to 3,500 to 4,000 different home inspection claims, and less than 1% of them have any validity. It's really quite remarkable.
It really is. And you would know those statistics better than anyone. Matter of fact, I'll throw ourselves in there. We have used Claims Intercept for many, many years. And you also have a service for inspection agreement audit. We actually had you audit an agreement many years ago before you had that service, and it was fantastic. But you actually squashed two claims for us. One was a seller who decided that they did not like our inspection, so they wanted to sue us. You kicked that one right out the door. We love that one. Another one is a seller and an engineer reported us to New York State, and you helped us craft the letter back to New York State. And interestingly, that engineer got in trouble for him interfering with our inspection from the letter that you helped us craft. We didn't want him to get in trouble, but
Right.
New York State said, "You do not interfere with another profession like this. You are out of line."
Really? Oh, that's
Yeah.
awesome.
Yeah,
Yeah.
we got an official letter back, and the agent shared with us what happened afterwards too. It was, you did a fantastic job with that. So
That's
lots of
great to
respect.
hear.
Yeah,
That's
a lot of
great.
respect over here.
Love hearing that. Yes.
Yeah.
Well, New York State is actually very good for home inspectors from a legal standpoint. There's actually a lower court ruling that there's no cause of action against home inspectors because it was preempted by the New York State Home Inspectors Act.
Yeah.
Now that's only a lower court ruling, and I use it all the time, so it seems to get a lot of respect from the other attorneys. So that's New York is great, and I'm sure we're talking to people in other states. There's other states. Texas is wonderful for home inspectors, and any state that enforces limitation liability agreements, limitation liability clauses is great for inspectors because it takes the wind out of the sails of plaintiffs' attorneys if they understand that there's nothing to be gained from pursuing the claim. Not that these claims have anything worth pursuing to begin with, but that really does seem to take the wind out of their sails.
Yeah, and I remember you mentioning that before about New York. I didn't know about Texas, but I remember you also like New York too because it's one of the places, and we'll talk about this later about arbitration clauses, where you can have an arbitration clause and a limitation of liability as well. I remember you saying that before.
That's correct. Yeah, that
Yeah.
is correct.
See, I listen, Joe. I've taken your Claims Academy. So we actually have some questions that guys have been asking about And it's interesting. I see these inspectors asking these questions, and then everybody just throwing out information online of what they think. But
Right.
it doesn't mean it's real legal information. So a couple of the questions we're going to ask: who owns the report? That's a big one that comes up all the time. Should I have an arbitration clause, or should I take things to court? Can I put a lien on a property after someone doesn't pay for the inspection? What can I do about fraudulent reviews from sellers or other inspectors? And ultimately, what should I do when I get a demand letter from an attorney? So I'd love
Right.
to hear a couple of your thoughts on this, especially the first one.
Who owns the report?
Yeah, who owns the report?
Well, the number of inspectors have copyrighted their reports, and it's pretty easy to copyright something. You just put copyright 2022 and whoever the inspector's name is. Uh, I don't I don't run into very many instances where, or any at all actually, where that is of any importance. Home inspectors, by and large, are very good at what they do. I mean, even the new guys. I remember when I was a new attorney, I would take forever on a case because I was worried. And I think a lot of these new inspectors, they do the same thing. They're worried about making a mistake, so they're super, super, super careful. In the 3,500 plus claims that I've responded to, there's never been an instance where ownership of the report was material or even came up. I don't think that's very important, actually.
Yeah, I guess the question comes up a lot because the scenario that I see the most of is an inspector says, "Hey, the buyer's agent gave my report to the seller's agent. Now I have a new buyer of a property that I inspected that my client walked away from, and they're calling me about the report." And it's kind of almost a, how dare they take my report? I own it.
Yeah, yeah. Well, that subsequent buyer has no claim against the original home inspector because the original home inspector does not owe a duty to that subsequent buyer. And that subsequent buyer has no basis for relying on a home inspection that was conducted by someone else. Generally speaking, as from a negligence standpoint, in negligence you have to prove four things. You have to prove that there was a duty owed to the plaintiff. Secondly, you got to prove that that duty was breached somehow. And thirdly, you got to prove that the breach of the duty was the cause of damages. So you need duty, breach, causation, and damages. And you almost never have causation in these cases. Like if you do an inspection for someone and 6 months later they discover there's a leak in the roof. You didn't put the leak there, so your inspection did not cause that leak. What it might have caused if you actually missed that leak, it might have caused the person to pay more for that house than he should have paid. And that's basically it. So the only thing they would be entitled to in that instance would be to have the roof leak repaired, a couple $100. A lot of people think that you can, if there's a leak in the roof, you get a new roof. That's not the case at all. All you're entitled to is to have the roof leak repaired, something that costs a couple of $100. These lawyers on the other end and these claimants, they think these claims are worth a lot more than they actually are.
Yeah, and it's interesting that you bring that up. I've always viewed somebody distributing my home inspection report as free advertising. If I wrote a great report, I want everybody in the universe to have my report. Agents, buyers, 30 buyers. Agents used to give them away at pre-listing and when I do a pre-listing inspection at an open house, they'd have them sitting there on a table.
That's a good point. I actually had a home inspector's client call me up, and he didn't have any complaint with his home inspector other than he didn't think the report was as good as the report as the prior inspector had done on his house for a previous buyer. He was selling his house. His buyer had a report done by a home inspector, and his seller loved that report, but hired a different home inspector to inspect the house he was buying, and he thought that report wasn't up to the standards of the previous report. So it was very interesting. So I think you're right, Ian, that there's nothing to lose from having someone look at your work product.
Right. Exactly. And so going back to that question, I agree with you. I think it's a great advertising piece, and there's really no liability in them having it.
There isn't.
But now, if we're a home inspector, though, and we say, well, we want to own our report. So now Joe said I can copyright it. So how do we go about copywriting a report if we're really just worried about that and we just want to make sure we own it? Is it just a matter of saying that we copyright it in the agreement?
It's just a matter. No, it's just a matter of writing copyright 2022 and then person's name, the inspector's name.
Oh,
And you can put that copyright symbol in there.
right in the report?
Yeah, but I don't think there's any real upside to copywriting your report. I think you're better off, as you pointed out, Ian, to let the world see it. You know,
Yeah.
if you're proud of your work product, let everybody see it.
Yeah, exactly. And that's what we produce as home inspectors. It's our report.
That's your
So,
product, right?
yeah. So if we didn't copyright the report, who technically owns it then? Would it be the purchaser of the home who hired us to inspect?
Well, I think so. I think ownership. Who owns? I'm reading a book now on William F. Buckley Jr. And who owns that book? I own the book. I bought the book,
Right.
so I own that book. But I can't start using pulling paragraphs out of there and putting them in my letters.
Right.
So yeah, who owns it? The person that purchased it owns it, I would say.
Am I using the correct legal term when I say it works for hire? Like if you hired an employee and they produce something for your company, and now that belongs to your company, it doesn't belong to the person who physically wrote it. Is that kind of the same thing?
That's kind of the same thing. Yeah,
Yeah, it works for hire unless you're going to copyright it.
that's right.
All right. I tell you what, that was the most clear answer to that question I've ever heard. There was a guy who posted a video and it was very long and wasn't as concise. So thank you thank you very much. That was a nice easy way to go about that.
But I think the takeaway there is what you said. Let people see what you do.
Yeah. 100% agree. I've gotten so much work over the years from people who saw a past report. It was awesome.
Right.
All right. So this one is a little bit of a question that I think there's some back and forth with a lot of people in the industry. Arbitration clauses. First of all, what is an arbitration clause? And in your opinion, do you think we should have it in our agreements or leave it out?
Of course, there's two schools of thought on this, and neither one of them is completely right or completely wrong. The reason I favor arbitration clauses is because quite a number of cases are at small claims court level. And small claims court level, you can defend yourself, even if you're a corporation in most jurisdictions. So we have a tutorial that we give out to people who have to go to small claims court. And you should always clear it with your insurance company that they'll allow you to go defend yourself. And my experience is that most of them will. And the thing about an arbitration clause in small claims court is that small claims courts and courts in general are limited in their jurisdiction over the subject matter. They're unlimited in their jurisdiction over the person. So if you inspected a property in Tarrytown, New York, you would be liable to be brought into court in Tarrytown. So they would have jurisdiction over your person. But if you have an arbitration clause that says that any dispute has to be resolved in arbitration, they don't have what is known as subject matter jurisdiction. They don't have jurisdiction over the subject matter of that claim. So in our small claims tutorial, our clients are batting 1,000 in small claims court based on this. If they have a arbitration clause, when you get into court, you say to the judge, Your Honor, I think I can make a motion that will shorten this proceeding. And they'll generally say, okay, what's your motion? And all you say is, Your Honor, the plaintiff and I, this dispute is governed by a contract that requires any disputes to be brought in arbitration. And what the judge will do is ask you for a copy of the contract, and of course you'll have one, and you'll have one for the plaintiff as well, and you'll have that clause highlighted. And you give it to the judge, and he'll say to the plaintiff, Sir, is this your signature on this contract? And they will agree that it is their signature. And the judge will say, well, you have to go to arbitration. We don't have jurisdiction over this matter because you agreed to arbitration. And our clients are batting 1,000 following that procedure. Now, every now and then, a judge will go, well, okay, let's proceed anyway. And in that case, you just go in and say, well, it was, this defect was concealed. This defect's outside the scope of the inspection. Or if you look on page 30 of our report, you'll see that we found that defect and told the plaintiff to have that reviewed before, further evaluated before closing. Or here's a photograph of that, fountain working during the inspection and so forth. So that's really the reason I favor arbitration clauses. Another reason is these home inspection claims that reach court always have multiple defendants in it. It's always the seller, the real estate agent, and the home inspector. And if the home inspector's a corporation, home inspector's corporation. None of these other defendants is going to have an arbitration clause with the plaintiff. Generally, lawyers don't want to fight in two different venues. So, they're more susceptible to letting you out, because you don't have a liability to begin with in most instances. I've often called up plaintiff's attorneys and told them that they don't really want the home inspector in the case. What they want is the home inspector testifying for your mutual client. If this is something that was concealed, the home inspector can testify on your client's behalf, your mutual client's behalf, that the defect was concealed. And sometimes these lawyers are happy to have that cooperation. So that's the reason I favor. You can go either way if you want to. I mean, I'm not married to the arbitration clause, but I do favor it.
Yeah, and I remember a while back, I think in one of your presentations, you also talked about meritless claims are easy to file for in small claims court. A lot of these places, $50, $60, and now you file a claim.
Well, that's the other thing.
Whereas arbitration, you actually have to be sure that you're right that this home inspector missed something, because arbitration's not cheap. It's like $1,000 to $2,000 a day, isn't it?
It's very expensive because the arbitrators are generally attorneys. And honest to God, these attorney fees are getting way, way out of control. I am just generally shocked by what attorneys charge for hourly rates in major cities. So yeah, you can run up the fees pretty quickly in arbitration. And the thing about arbitration is if your agreement calls for arbitration, it should also call for the plaintiff to pay the arbitration costs, the initial costs anyway. And they're about $600 just to get started. So someone's got to have a pretty good claim before they're going to spend $600.
Yeah, that makes a lot of sense. And thank you for putting some context on that too. So the third question we have, and this one is kind of an interesting one. I kind of wonder about this myself. I've never had to go through this, but can I put a lien on a property after someone doesn't pay for the inspection?
No, you can't, because first of all, your client doesn't own that property. It's owned by somebody else. It's owned by a seller. So you would really be getting into trouble if you did do that, because that's a cloud on the title, and you're going to get tremendous pushback on
Yeah.
that.
I can't imagine that would be a pretty situation to be in.
No, it wouldn't. It wouldn't. It would not.
So what kind of avenue can an inspector go through to if somebody doesn't pay for the inspection?
Well, first of all, you should never not get paid twice. You know, after the first time you get stiffed, you should really make a practice of being paid before the inspection. I know there's a lot of places that there's a tradition of paying at closing, but of course, not every inspection results in a closing. So I think it's a good idea to have a business practice where you absolutely will not go out. You won't leave the house until you've been paid. And today with so many products out there, so many software products where people can pay online, can sign the inspection agreement online. I know you're saying there's no excuse for having to go to small claims court to be paid, and that's really your only avenue. Your other avenue could possibly be filing a private criminal complaint for theft of services. But you're better off, I'll tell you what, if you're charging $500, $400 for an inspection, how much time do you want to waste collecting $500?
Right.
So you're better off getting paid ahead of time. And I actually don't get very many calls from inspectors about that. I really don't.
Yeah, I see this question a lot. There's been very few times, actually, technically only once, where somebody didn't finally pay up. But this is probably a good plug spot for our software. Just what Joe said there. You can get your agreement signed online, get paid online, all that before you show up with Inspector Toolbelt. Great features to have. Even on our free version, you can have that. But like Joe said, sometimes it's just cutting your losses and moving on.
Right.
And I think your expression there, Joe, of you don't want to get not paid twice. So if you haven't been paid, fix that situation. And now it's just an expensive lesson. Yeah.
That's right. And while we're on that subject, I want to talk a little bit about home inspectors being too prone to give money back when they haven't done anything wrong. I've seen a lot of inspectors that are very, very quick to refund an inspection fee when it really, the thing was outside the scope of the inspection, or it was not visible, or it was, disclaimed. You disclaimed it, and you disclaimed it, and you told them to have it further evaluated. You did nothing wrong. There's no reason not to get paid, and there's no reason to return that fee.
Yeah, it's not a good overall business practice to give back money when the services were already rendered.
Yeah, I think it's a bad habit to develop, because not only are you losing money on a fairly regular basis, if that's your MO, but in a lot of instances, it's an entry-level drug for these claimants. It's like, whoa, maybe this guy did more than, maybe there are other things he missed, so, and the cardinal sin is giving money back without getting a release.
Oh,
Don't ever do that.
Yeah, that's scary. That's a scary thought right there.
Well, the other thing is sometimes when you go to give a guy the money back and ask for a release, they get their backup, So you're really better off just sticking to your guns and saying, I just had a case out in California. It's kind of interesting. Los Angeles. Never rains in Southern California. Remember that song? Well, about a month ago, they had a 100-year storm. It was isolated basically in the LA County. It was isolated. 10 inches of rain fell in 24 hours. 10 inches of rain. So the inspector had done the inspection back in September. And the guy was complaining because water was pooling in his yard. Imagine, imagine that. 10 inches of rain. So I told the inspector, I said, look, first of all, we don't do hydrological inspections. That's number one. But number two, come on. 10 inches of rain? I mean, be reasonable, tell the guy. I never heard back from the inspector, so I assumed that went away. I mean, but that's how crazy people are. They think you're gonna be responsible for the rest of their lives for anything that goes wrong in the house. It's really quite remarkable to me.
It is to me too. I mean, just as a home inspector, I've had people call back. One guy was 6 months after he closed. My dishwasher doesn't work. My question was, I said it nicely, did you not wash dishes for 6 months? He goes, no, it worked fine right up until now. And I'm like, welcome to homeownership.
Right, exactly.
He wanted money back. I'm like, yeah, no, I'm good.
Well, my personal record is 12 years for a roof leak.
Oh my goodness.
Yeah, can you imagine? Did not rain for 12 years,
Yeah.
That's
It's a weird mentality that people go.
It really
into
is.
a house.
Yeah. It really, well, it's not even confined to houses either. A friend of mine was just in a minor auto accident about 2 years ago, and the guy in the striking vehicle, the guy that hit him, sued. And his insurance company gave the guy $47,000. He, of course, was outraged, I don't know how that's possible. These insurance companies, they're so risk averse. I guess they didn't want to try a case
That is
anymore.
odd.
It is odd. It's very odd.
But that's unfortunately how the world runs nowadays.
Yeah, and that's why premiums go up, because he got morons. He got morons running these insurance companies.
Yeah, and that's maybe we could have you on the show another time. We would love to talk about insurance companies paying out and premiums and stuff like that, because you've had some interesting thoughts on that in the past too, that I'd love to talk to you about. But the fourth question that we wanted to ask you about, a lot of home inspectors ask, what can they do about fraudulent reviews from sellers or other inspectors? And I got to tell you, I have seen this so much. I have seen other inspectors get all their friends to, unfortunately, uh, it's a sad thing. We're a good, honorable industry, but once in a while that's going to happen. Somebody's a little cutthroat, doesn't like you. I had one guy, he had like 7, 8, 9 every day more reviews added on from a competitor. Sellers, I've had that happen. Sellers have left me bad reviews. That hole in my roof was meant to be there. That's how I fill up my bucket in my attic, kind of thing.
Right.
What can we do about that?
Well, I think, unfortunately, a lot of the times these reviews, these bad reviews, don't have any name attached to them. You suspect it's a seller, or you suspect it's a competitor, but there's no one to go after. Now, I've had probably over the years, I probably have had about 15 or 20 people who actually went and put up bad reviews on people. I remember one a couple of years ago. It was in Philadelphia, and the guy put up this terrible review. And the thing of it was that the inspector had pointed everything that he was complaining about, had pointed it out to him. So I wrote that guy a really firm letter to the extent that if that review was not removed, there would be real serious consequences. And the guy removed it almost immediately. And the thing is, you really do have a hammer, because that's defamation. If you're a home inspector and someone goes online and says all these terrible things about your workmanship, about your abilities, and they're not true, Well, you have a defamation claim against that person if the person is identifiable. And as I said, I've done this about 15 times, maybe possibly 20 times in the last 20 years. So I don't have a lot of experience at it. And that's also indicative of how seldom it really comes up, at least in my experience. But I'm batting 1,000. I'm batting 1,000 at getting people to take those things down. But that's too small a sample as far as I'm concerned. To make any extrapolate any theories about it. But you do have it's a really powerful thing, the threat of a defamation lawsuit. And here's the reason why. In defamation per se, which defamation per se is things against your personal morality. If they say this person's a rapist and they're not, or this doctor is a quack, things like that. That's called defamation per se. And the thing about defamation per se that makes it the best of all torts, according to the late attorney in Philadelphia, after whom my law school is named, after he gave them $25 million. He said that's the best tort that there is because you don't have to prove damages. In other words, you don't have to say, hey, I lost 15 inspections because you put that up there. And some of these, and juries throughout the nation, throughout the length and breadth of this nation, have absolutely no problem coming back with multi-million-dollar verdicts against defendants in those cases. And that's something I always point out when I'm writing a letter like that. I point out to them, look, you're in Pennsylvania. This jury returned $8 million verdict against somebody in a defamation case. And those verdicts are out there. You can search Google. You can search Google and put defamation per se, damages, New York State, and you'll get returns showing spectacular damage awards. I mean, really huge. There was one up in New Hampshire. This is really egregious, though. This was a guy who defamed people on billboards.
Oh my goodness!
That verdict was about $40 million. It was crazy. Yeah.
Oh my goodness! Yeah, if somebody goes that far, then yeah, they're digging their own hole.
Well, the thing of it is, you get a $40 million verdict against me. Okay, I'm never going to be able to borrow money again, but you're not getting 40 million, because I don't have 40 million. But this defendant did have it, so that was pretty sweet for the plaintiffs in that case.
Yeah, and I think I'm going to go out on a limb here too, because I remember a discussion that you had, and I want to say it's Barbara Streisand that you used as an example, but I can't.
Right.
But it's the Barbara Streisand effect, I think you called it.
The Barbara Streisand effect, yeah.
Yeah, tell us about, like, we may think, okay, well, I know this seller, I can identify her, but what bearing does the Barbara Streisand effect maybe have on it?
Well, the Barbara Streisand effect. Barbara Streisand has this spectacular home on the Pacific Ocean, and many years ago, the NOAA, National Oceanic and Aeronautical Association, I think, a government operation, engaged a photographer to fly up the California coastline and take photographs of the coastline in order to have a starting place for subsequent erosion. They could go up, 5 years later and photograph the same things and see what the differences were. Well, Barbara Streisand took exception to this fellow putting these photographs on his website, and she asked him to take them down, and he wouldn't take them down because that was part of his obligation to the NOAA, was to keep them up there. And the deal was that prior to her filing the lawsuit, her photograph of her home had been downloaded I'm going to say maybe 70 times. In the 6 weeks after she filed the lawsuit, because when you file a lawsuit, TMZ goes in and sees if there's any celebrities that are filing lawsuits. So they went in, and of course they publicized that she was filing this lawsuit for this reason. And in the 6 weeks subsequent to her filing the lawsuit, it was downloaded something like 180,000 times. So the point of the Streisand effect is that sometimes when you call attention to stuff, in other words, I always counsel inspectors not to respond online to these defamations, because sometimes a guy will double down, and then you get into and then it calls attention. It calls attention to that particular bad review, and of course these sites, Yelp and Google and Angie's List and Better Business Bureau, that is their stock in trade. That's what they deal in. So they pump those things up to the top. So you're better off, if you don't want to go after the guy in court, you're better off oftentimes just ignoring it, because people will have 7 or 18 or 19 good reviews that will dwarf that bad review.
Yeah, and that's a good point. Like when I went to a restaurant recently, it had 4.8 stars. They had 2 reviews that said they wouldn't let their dog eat there, basically. I didn't listen to them because there's always going to be that 1 or 2 guys that you really
Right.
can't make happy. And they just
Right.
buried it in good reviews, great place to eat, and everybody moved on. So that's great advice. We don't want to draw too much attention to it.
Yeah, you don't want to draw too much attention to it, and you really want to get along with your life too.
Yeah.
That's not to say that these things don't eat you up for a week or so.
Yeah.
It's human nature. You're going to be upset by something like that, but you're often better off just not doing anything.
Yeah.
You're a good inspector. You've been in business for X number of years, done thousands of inspections. You're not gonna please everybody every time.
Yeah. Matter of fact, as inspectors, we walk away from most transactions with at least one person not liking us.
Oh yeah, without a doubt. Yeah.
So I don't want to keep it too long, Joe, because you've been more than generous with your time, and I'm loving this discussion. But I wanted to get your answer to that last question. What should we do if we get a demand letter from an attorney? Because I think that's the most common thing that we worry about. A friend of mine, actually, who used to work for one of my inspection companies and went off and started his own, he recently got a demand letter. I looked at it and I didn't give legal advice, and I go, so,
Yeah.
So
Right.
what do we do?
Well, if you get a demand letter, generally these lawyers are not. They think these cases are worth a lot more than they actually are, and my clients, what they do when they get a demand letter is they send it to me, and I will respond to attorney or just a lay person, a lay claimant. I'll respond to that with chapter and verse on why their claim is invalid. It's because it's outside the scope of the inspection, because it was concealed at the time of the inspection, because it was disclaimed at the time of the inspection. The crawl space you couldn't get into it. It was only 10-inch opening. So you disclaimed anything having to do with the crawl space. Or it was something you found. You'd be surprised how oftentimes people are complaining about things that they were told about. Or finally, it's something that was working at the time of the inspection. You'd be surprised by that too. You get a claim for something with the water flow, and then you look in your report and there's a photograph, or sometimes even a video, of the faucet running, the shower running, things of that nature. So, we weren't negligent. That's the first line of defense. And then oftentimes, these people that don't read these reports, hey, we told you about that roof. did you have it evaluated like we asked you to? Well, no, I didn't. Okay, well, not only were we not negligent, you were negligent. You were contributorily negligent, and that's a complete defense in most states. And in every state, it's a complete defense. Or even if we were negligent, which we weren't, and even if you weren't negligent, which you were, you don't have any damages. All right, your roof's leaking. Yeah, you don't get a new roof, you get the leak fixed. And by the way, also, you can't bring a negligence claim because of the economic loss doctrine. Economic loss doctrine basically says that, unless there's property damage caused by the tortfeasor, unless that was caused, which I said earlier in this podcast, you don't cause these leaks. The inspection doesn't cause the leak, unless it was caused by the inspection, or unless there was bodily injury caused by the inspector. That's economic loss, and in a lot of states, pure economic loss is not recoverable in tort. So you're out of luck there. Oh, and by the way, even if you weren't negligent, which you were, and even if you had damages, which you don't have, and even if the economic loss doctrine didn't apply, which it does, we have an agreement that says any loss is limited to the amount of the inspection fee. Well, an attorney gets that letter, he's really like, holy smokes, I didn't know any of this, which they don't. They think every claim's an auto accident. It's not. It's, a home inspection is completely different from an auto accident. So they generally go away. And lawyers go away faster than lay people because they don't want to waste their time on a case that's doesn't have any value to it. So, and then what happens then, after I write the letter, then you notify your insurance carrier, and the insurance carrier is generally delighted that I have responded, because what they do then is they put a 45-day pending on that claim, and then if I haven't heard from the claimant, or if the inspector hasn't heard from the claimant in 45 days, they close the file. So there's no claim, nothing.
Nice. You're talking about this subject really makes me feel good, because I think a lot of us as home inspectors, especially new guys, if we've never had a claim, if we've never had an issue with a client, one of the things that we worry about the most as a new guy is, oh my goodness, everybody's talking about getting sued. Everybody's talking about this or that. There are a lot of layers between the client and us, and especially if we work with someone like you who knows these laws inside and out. So it sounds like we're well protected to be able to do a good job for people and to be able to sleep at night.
Yeah, well, as I said earlier, I think home inspectors are generally not negligent. Professionals in general are generally not negligent. Why? Because they're professionals. They do this thing. They do this hundreds of thousands of times. Hundreds of times, thousands of times. I bet, Ian, the next house you inspect, you will inspect it exactly the same way you did the last house you inspected. You have a routine. You know what you're doing. You know where the pitfalls are. Professionals in general are generally not negligent. And when I was working up for the seminars that I used to do, I was doing research, and I discovered that 95% of the professional liability claims that go to trial result in a defense verdict. The defendant was not negligent.
Oh, wow.
And why is that? Yeah. Well, here's a good example. A person has a surgery, and you go into the surgical theater. The theater is sterile. All the instruments are sterile. The surgeon is gowned, masked, gloved. All the supporting people are gloved and masked and gowned. And the surgical patient, he's completely draped, totally draped. And the only thing that's exposed is the 2 square inches where they're going to make the incision, and those 2 square inches are bombarded with germicides. So, there's less than a 1% chance that anything is going to go wrong. I think it's something like one in 500 surgeries results in a claim, and there's no negligence because they did everything they could possibly do to prevent that. They didn't do anything wrong. That's why they get a defense verdict. So, over 3,500 claims I've responded to, only a handful, less than 7, have been where there was actually merit to the claim. And I didn't have to tell the inspector that. The inspector told me. He said, Joe, I think I actually did miss this. Well, in that case, there's nothing I can do. I can't block a meritorious claim. A meritless claim, that's actually a piece of cake for me.
Right.
Do I block them all? No, because there's knuckleheads in the world. Some people are completely impervious to forced hand levels of logic. They just don't get it. They continue the march.
I tell you, the information you've given us on this podcast has been some of the most informative that we've had yet. Anecdotally, and your information has been spot on, as always. We'd love to have you on the show again sometime in the future, because we could talk for hours and hours on this stuff, because there's so many questions rolling around in my head. I have to control myself.
Yeah, well, without a doubt, I'm happy to come back.
Well, thank you very much, Joe, for being on the show, for sharing your wisdom and your insight. I know the inspection industry appreciates everything that you do. And it's interesting, even before the podcast, Joe's like, I want this to 100% benefit the home inspection industry. And that's what Joe's always been about. Visit his website, joeferry.com. If anything, at the very least, check out the Claims Academy. I always enjoy those. They're very informative. And keep a lookout for Joe in the future on Inspector Toolbelt Talk. Thanks again, Joe.
All right, Ian. Thanks so much for having me.
Thank you.
On behalf of myself, Ian, and the entire ITB team, thank you for listening to this episode. Don't forget to hit that subscribe button so you can catch our future episodes as well. And if you have any feedback, please send us an email at info@inspectortoolbelt.com. Also, don't forget to check out our brand new app for home inspectors, scheduling and report writing all in one easy-to-use app. Check it out now at inspectortoolbelt.com.